Okay. Good evening. This is the San Joaquin County Civil Service Commission meeting, March 9th, 2022. It's 5:30 and I call this meeting to order.
Thank you. Donna, will you do roll call?
Certainly. Commissioner Lofstrom,
Present.
Commissioner Piccone,
Here.
Commissioner Gutierrez.
Present.
Thank you.
Thank you. First order of business is to go through the agenda. Ms. Hopkins, will you take us through the agenda? Thank you.
Will do. Thank you, Chair. Our first item tonight is to approve the minutes of the February 9th, 2022 meeting.
Thank you.
I'll move to approve the minutes.
I'll second the motion.
All those in favor say aye
Aye.
and opposed no. It passed.
Thank you, Commissioners. Our second item tonight are reports of disciplinary action. And for tonight, we do not have any to report to the Commission related to reduction in salary, dismissal, demotion, or suspension. Our third item this evening are communications. Our first one, Commission vacancy and status follow-up. This is our new standing item so that the Commission can discuss with me or amongst yourselves our vacancies and status follow-up. From an HR perspective and as your staff person, I do not have any new status follow-up other than what we reported last time. We shared when everybody's terms were expiring and the board's efforts and how they go about filling these positions.
Okay, thank you. Does anyone have any questions or comments they want to make on the commission?
Yeah, I just want to say, has the board recognized that there's only going to be maybe two after the next meeting, two commissioners? Because John, I'm talking about the board of supervisors. Do they recognize that?
The clerk of the board is aware and she reports to them. And I do plan on sharing that with them as we move forward.
Okay, so when we have a meeting of just the three of us, that's enough for a quorum, right? We can conduct business. Correct? Is that right?
That is correct. When we go down to two, we will no longer have a quorum. We won't be able to vote on the matters.
And I was just talking with John about, in the past that there was a time when they went like 5 months without a meeting. That should be worrisome, I would think. I hope we don't have that happen. Like John, I'd rather him stay on if he could. And then we only have three. That's a quorum. Can we pass things with just 2 votes when we only have 3 on the board?
Are you asking, I'll make sure I understand the question, if all 3 of you tonight, if 2 of you voted yes and 1 of you voted no?
Correct. Would that be enough to pass? Would you know? Now, Mark, can you tell us if
I think what he's asking is that if there's only 3 members on a 5-member panel and 2 of the 3 members show up, the third one doesn't, does the quorum now go to 2 and 3, or is it still 3 and 5?
That's not what I'm asking.
Oh, okay.
I understand it takes 3 for a quorum because of 5 members. It
Mhm.
always will be 3. But when 3 do meet, can we pass a resolution or a motion with just 2 votes? Or does it take all 3? Do you know, Mark?
Standard rules of, Robert's Rules of Order would be majority of the quorum takes action unless there's some specific, occasionally there's a statute that says, I know like with school boards, they have to have a majority of the entire board. Some of the school boards have to have that. So if it's a 7-member board and they got a 4-member quorum, they have to have 4 affirmative votes to take action. I don't think there's a provision like that for the Civil Service Commission.
I have not seen that in our civil service rules.
And the county council's here, he can correct me, but ordinarily, if you have a quorum, then a majority of the quorum can take action.
A majority of the.
2 to
quorum.
1 would still work.
Okay.
But if one of you gets up and leaves, then you lose your quorum and then you can't do anything further.
Okay, so it could pass with just 2 votes.
As long
If
as
there's
all
only
3 of
3.
you here. Yeah.
We had an example of that. I don't recall if it was last meeting, but I think it was, where there was 2 votes on something and 1 was different. So
No, I wanted to make sure that was.
that was legal what we
Yeah,
did.
Yeah, I just got, because
Yeah.
I don't want to have a problem in the future. Okay.
Well, thank you. We appreciate your continuing to bring that up, and I'm aware, we're all aware you share our same concern. So thank you.
We do, and we'll continue to update you.
Sure.
Our second communication item tonight, the commission asked after our meeting last month to have a discussion about Rule 20, which is the county's equal rights practices. So we've invited County Counsel Mark Miles to speak this evening.
Good evening. The question that was relayed to me was whether, see, I've got it here in my notes.
I'm sorry. I recall talking about that. I just don't see it on the agenda.
It's under communication, Dottie. I'm sorry, Chair.
Page 1.
Bottom of page 1, communications, A, commission vacancy, B, Rule 20.
Oh, it would help if I
discrimination
went to the
discussion.
March agenda. Sorry, I beg your pardon. Okay.
No worries. I was doing that on my screen a little while ago. But thank you, because I could be looking at the wrong document.
The question that was presented to me was in Rule 20, Section 5, it states that the commission may, quote, order remedial or restorative actions. One of the commissioners is interpreting this to mean that the commission could order the county to return a released employee from work, provide back pay, restore accruals, et cetera, and ask that county council review this. I have looked at the civil service, the County Civil Service Enabling Act, the county code requiring that the commission adopt rules to carry out the civil service code. And it states that the rules are to have the force and effect of law. I interpret that to mean that the rules are binding and not merely advisory. The provision in Section 5 actually states in full that the commission may also order appropriate remedial or restorative actions that is in conformity with these rules, the county's memorandums of understanding, work rules, policies, and practices. So the answer to the question is yes, that the board may order some restorative and remedial actions, provided that the restorative action is consistent with the other rules of the Civil Service Commission, the MOUs, and the policies and procedures.
The MOU, could we get a copy of it? Or is it a big, so that we could,
Yeah, all of the memorandums of understanding for the labor agreements are online, but we can send them to you.
Okay, is it, how many pages is it?
Well, I think there's
Well-
13 of them and they're probably all 50, 60 pages each.
Oh, each one?
They're all very similar. Once you figure out the similarities, there's only slight differences in certain places, but we can get them to you.
Oh, okay, I can understand that. And then the work rules, the county, you mentioned the county work rules. Where are they? Where do you find them?
Those are online as well. We can get you a copy.
Oh, okay. Uh, What I wanted to also understand is that just the process that one goes through, if they make a discrimination complaint, then there's the informal process, and that they go through that, they can go through that first, the complainant.
Yes.
Okay. There is a point where they can, well, when they go through the process and they get to a point where they are not happy with their result and they want to they ask for an appeal hearing here to our board. Do they have a choice instead of asking for an appeal here before our board for a hearing, to go to arbitration or meet, like in some of the other situations where they, the complainant can choose to go to arbitration instead of having an appeal here? Am I making myself clear in my question?
You are. The appeal hearing process is not to arbitration. The appeal hearing process is to this body.
Yes, I understand, but instead of doing that, do they have a choice of going to an arbitration, or is it arbitration or mediation?
That's under a different rule. That's on disciplinary hearings.
That's on disciplinary.
They can choose arbitration or a hearing in front of the commission. I think on Rule 20, their only right is to come here.
I'm sorry, I didn't hear that.
Their only right under Rule 20 is to come here.
Oh, they can't choose
But
to.
on Rule 18 on disciplinary matters, they have a option to go to arbitration.
Yeah, and
Rule by rule, how that goes.
yeah, I'm glad that I see most of the time they do choose.
But they used
arbitration.
to come here a lot. We used to have a lot of lengthy hearings and hardly ever have those anymore.
And the arbitration hearings, now that you brought it up, I want to ask, who are the arbitrators? Are they outside arbitrators or are they here within the county employees? The reason I ask is I understand, as when I was practicing law, many of us would volunteer to be arbitrators, and so that we would then hear cases and arbitrate them. And then there was either binding arbitration or there was not non-binding. Are the arbitrators that are in that other rule, are they outside lawyers that hear it?
That's my understanding.
The employee has the rights, the employee center has the right to offer up 5 names. The county has the right to offer 5 names and they decide on 1 name. And that pool is usually from outside the county. The arbitrator is usually from outside the county.
Okay, that's what I recall how it was. So here they can only request for a hearing, and we get to decide whether we want to hear it or not.
Correct.
Right?
Yep.
And when we meet and decide whether we want to hear it or not, when we come out, and we discussed that in closed session, and we make a decision in closed session, or we don't make a decision. What I'm concerned about also is when you come out, if you're not going to have a hearing, you basically have denied it. If you have a vote on that, isn't that an action taken that should be reported on the record when you get out?
Well,
Of-
you would report it, but it doesn't necessarily require that you do a roll call or a vote. It's just the board has decided in closed session, either to grant a hearing or not grant a hearing.
Well, that means an action was taken. But what,
When you take it into closed session, you decide whether or not to grant a hearing. Either way, it's an action. If you decide not to grant a hearing, that's an action.
well, but you don't come out and say no action was taken.
No. You do that if you are considering something in the personnel area, like whether to fire somebody or whatever else. And if you don't decide that in the closed session, the chair is supposed to come out and say that she has nothing to report from the closed session. But on the Rule 20 appeal, you either grant the request for a hearing or you don't. And that either way, that's an action.
Well, that's, but I think it's then should be reported
And we do.
instead of, no, what we've been doing is say no action was taken.
No, we don't. Not on the Rule 20. We report that there was no hearing. The commission decided not to grant a hearing.
Oh, okay, and that should be on the record, shouldn't it?
Sure. Yeah, we reconvene an open session.
I could
And-
understand if we discussed a matter and nobody made a motion to do either way.
Well,
You Then you could
deny
say
it.
no action was taken.
No, then you deny it. I mean, if no action is taken, if you can't get a consensus, then it failed, the appeal fails for lack of by the commission. It's an affirmative thing. Either you grant a hearing or you don't. If somebody makes a motion, says, I want to grant a hearing, and it ends up 2-2, if we had a fourth commissioner.
I think at our last commission meeting, Commissioner Gutierrez was.
No, we don't want to talk about what happened in closed section.
Was concerned about our report out after the
Right.
fact.
Yeah.
So I think in the future, what we can do is make sure between council and me that we have a script that makes it easier. Because I think that was the concern you talked to me about, was how it
Yes.
was reported
Right,
back in open session.
right. That's correct.
And I understand what your concern is. I generally look to Mr. Ornelas to give me guidance on what to say, and I don't question it. I pretty much say what I'm advised to say when we get back, because I don't want to step over any sort of line that I shouldn't be stepping over.
That's correct. Good job.
Yeah, I understand that. Okay, then, the other question that I had about Rule 20 is if the board has a hearing, I mean, if once this decide to have a hearing and we have a hearing, thank God we haven't had to go through that yet. But if we do, and we have a hearing and we take a position different from the staff position, the staff recommendation or whatever, what happens then? And can we do that? I guess we wouldn't have a hearing unless we did, huh? Let me make it more pointed. If we disagree with the conclusion that the staff has made about something, and we disagree with it, and we agree with the complainant, what happens then? How is that then when we can make an order?
Let me see if I can find it here in the, give me a second. That's where I was looking at. So the appeal that's coming is an appeal because either the
point-
EEO office has concluded that the allegation of discrimination has not been sustained, or alternatively, they've concluded that there has been a violation, but the appointing authority disagrees with that conclusion and indicates he or she will not take any or all remedial or restorative actions. That's the point at which the individual can file the request for an appeal. Right?
Right. And the appointing authority is, that's the department head, huh? Like,
Yes, yes.
the head of each department is actually the appointing authority for
Yes.
the employees in their department.
Yes.
Okay,
If the decision of the commission is that the alleged acts constituted discrimination under this rule, the commission shall issue an order requiring the person who has committed the discrimination to cease and desist from such action in the future. So if the EEO office found that there was no discrimination, the Civil Service Commission could disagree with that and issue an order directing that the individual cease and desist from further actions.
Can I ask a follow-up question on that? So if that would be following an investigation though, right? I mean, we wouldn't just listen to them and say, well, this is what we think. We would listen and say, we think an additional investigation might uncover some more evidence or something, and we would order an
Well,
investigation, right?
at the point that it comes to the Civil Service Commission, there will have been a full investigation that's already been completed.
Yes.
And so you would have been provided with that information from the full investigation. And then you will hear from the parties to the appeal about why they think that, why they disagree with either the findings from the EEO office or why they disagree with the actions of the appointing authority. And then it's up to the Civil Service Commission to make a decision based on that record that's presented here.
What's not addressed, I don't think, in the rule is if you decide to grant a hearing, the rule doesn't really describe how that hearing is conducted. It's a little bit vague in that respect, but generally speaking, a hearing means you're going to listen to the appellant, probably the appointing authority, maybe the person who was engaged to do the investigation would come in and answer questions. But you have a record, as Mr. Miles says, you have the investigation that's already been done. And you may read through it and listen to the parties and decide that the investigator decided 2 and 2 was 4, and you think, no, 2 and 2 is 5 in this case. We don't agree with the conclusion. And the rule says you can issue an order to cease and desist, which is pretty minimal remedy. You're not awarding back salary, you're not putting somebody, giving a promotion that they were denied or that sort of thing. So there's more that's going to happen after that kind of decision that gets rendered if it gets to that. But the gray area is actually how you conduct the hearing, and that's where you would turn to me and say, what do we do now?
and then after, if the board commissioners decide that, that there is the discrimination and that the orders that they can make, I'd like to understand what order, what capacity do we have? What kind of authority? If we did order of course, they'd have to be in conformity with the memorandum of understanding and so forth. Remedial remedial or restorative actions. I want to understand what that entices or includes. Would
There
that be,
isn't,
would that be whatever the commission thought is remedial and appropriate?
well, yes, I think that's the starting place is remedial and appropriate remedial and restorative actions that are inconsistent with these, that are consistent with these other documents.
Right. Okay. And then my understanding is that if we did order something like that and the appointing authority disagreed with it, would they then have a remedy to go before the full board of the county board? We're all under the board of the county board, elected board. Is that's the way I looked at it and thought that, I don't know if it's ever happened, but would that be?
No, I don't believe that the remedy is to go before the Board of Supervisors. I believe that the remedy would be an action in court.
Okay, I think you've been very helpful. I appreciate the time that you've taken. Is there any other thing that you wanted to say about that rule?
No.
Okay.
Before we release county council, do any of the other commissioners have any questions?
I do not at this time, thank you.
Thank you, county council. We appreciate your time tonight.
Thank you very much.
Chair, are you ready to move forward?
We are.
Great,
Yes.
thank you. We do not have any old business for the commission to hear tonight. Under new business, there are no amendments of class specifications. We do have 2 adoptions of class specifications. Both will be heard with Ms. Brimmer tonight. The first one is classification project 19-030. It's for San Joaquin General Hospital. This is to adopt the class specification for Radiologic Technologist 3, I'm going to say this wrong, Magnetic Renaissance. And on the line, I believe we have a vet. We have a couple hospital people on the line tonight for both of them, so we'll confirm as we move forward. If you have any questions, we do have 2 staff people present. Yes, no, Amy, next to Dottie, please.
Right? Are you going to swear me in? Thank you. Good evening, Chair and Commissioners. We will have 2 items for classification on the agenda tonight to adopt new classifications, and they will be used at San Joaquin General Hospital. The Radiologic Technologist 3 magnetic resonance is the first on your agenda. Historically, San Joaquin General Hospital has utilized the existing class specification of Radiologic Technologist 3 special procedures to recruit for the magnetic resonance imaging technologists. We've had difficulty attracting applicants with the background and training required to perform this modality. And so by making the title, class description, and minimum qualifications more clear about the type of work to be performed, we hope to increase the candidate pools. The class specification is before you. We have had it forwarded to the representation, which is SEIU, and notified them, and no objection was made. As Brandy mentioned, we do, or as Ms. Hopkins mentioned, we do have the Manager of Diagnostic Imaging, Yvette Quiros, available should you have questions of the department.
Thank you. So I do have a comment. I know it's just a typo, but it's disturbing to me, so just want to correct it. It's only on the cover sheet. So you call it a radiologic technologist, but on the cover sheet, you twice refer to it as a technician. And if you know radiologic technologists, they're very sensitive to this. And so I just wanted to make sure that assuming we adopt it, that we adopt it for the radiologic technologist 3, not technician.
And
That's
we
it.
can correct the cover sheet
It's
too.
just the cover sheet.
No, thank you. We appreciate that.
Okay,
Duly noted, thank you.
that was it for me.
No, I have no questions.
Okay, so a motion,
I'll move to adopt the resolution, the
I'll second the-
recommendation.
I'll second the motion.
all those in favor say aye.
Aye.
Aye, and opposed say no. Okay, the motion has passed.
Our second adoption of class specifications for tonight is classification project 21030, also for San Joaquin General Hospital, and this is to adopt the class specification for cardiac monitor technician.
Currently, we have employees or the hospital has employees in the nursing assistant classification receiving intermittent supplemental pay to perform telemetry duties in the progressive care unit. Nursing assistants are required to complete a specialized training to perform this work, and they've been performing it on a regular basis such that the need for assigned dedicated positions has come about. So what we're doing is presenting to you a class specification that will represent qualifications and duties that coincide with telemetry work, and to be able to fill that regular ongoing need with that separate classification to which positions can be assigned. We have presented this classification as well to the union SEIU, with which this classification will be aligned. And we have the representative, Zainab Bordak is the Deputy Director of Nursing, available for questions should you have any of the department.
Thank you. Are there any questions or discussion on this? If not, I'll entertain a motion.
I move that we approve the recommendation.
I'll second it.
All those in favor say aye.
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 Opposed say no. Motion passed.
Thank you, Ms. Bremer.
Thank you.
There are no classification studies for the commission to consider tonight. We also do not have any staff reports. Under request for appeal hearings, there are no requests for appeal hearings under Rule 3 classification, Rule 18 dismissal, suspension, demotion, or reduction in pay, or Rule 19 violation of rules. We do have an item under other requests. We have an item tonight for the board to consider to approve a resolution amending the time of the regularly scheduled meetings. So as this commission is aware, we've had some discussions on and off about increasing participation, whether that be with the commissioners or with staff. And under your advisement, we are bringing forward a recommendation tonight to move the meeting time from 5:30 p.m. to 2:30 p.m. So that is up for your consideration, or any questions or comments you might have for me, I can answer them for you.
Do either of you have any questions or comments?
No, I would approve that change myself too.
So do you want to make a motion?
Sure, I move that we, the proposed change of regular time, that's recommended that we adopt it for our future meetings.
Before I second it, this takes effect on April 13th. If it's at 2:30 on April 13th, I can't make it. I can make the nighttime, but I can't make the daytime.
Here's what we could do, I think, because we had a special meeting at 2:30 when we were having a hard time getting it, 5:30. So we could go ahead with the resolution, but have a special meeting. Would that be all right? Or would it be simpler,
Why don't-
smoother,
why
just
don't-
make it the
If it may.
following,
Let's see, oh, there won't be.
just make it following in May? Okay.
Yeah, I'll change my motion to make it effective.
Yeah. So that'd be a May 11th effective date.
Okay, so will you have to retype this? I was thinking you wouldn't have to retype that.
Oh, my goodness.
It's not a typewriter anymore. It'll be quick.
Memory typewriter.
I know, I was thinking of signing it. Oh, but I'll just sign it next time. Okay, that's what we'll do. All right, so go ahead
Okay,
with your motion.
I changed my motion to make it effective May.
Second.
Okay, all those in favor say aye.
Aye.
Opposed, no. All right, the resolution motion passed. Thank you.
Thank you, commissioners. Our next item up is to set a date for an appeal hearing, and this is under Rule 3 classification. We have a request to set an appeal date for April 13th of 2022 for 3 current incumbents.
So it sounds like we're all going to be here on April 13th. We're all committed as long as we do it at 5:30.
I'm having eye surgery. I should be okay by the nighttime.
Okay. Okay. So we don't need to make a motion for this. We can just set the date.
Mr. Annalis, I think they
I
need
think we
to
have to
make
make
a
a mo-
motion
Does it need to
because
be a
they're
motion?
agreeing to the date.
When in doubt, make a motion.
Okay,
Yeah, that's a
please
good
make
point.
them, thank you. I'm going to remember that.
All right then.
Okay, I'll move that we have their hearing on April 13th.
I'll second it.
All those in favor say aye.
Aye.
Those opposed say no. And
It's all the same. It's a behavioral health. Off the top of my head, I can't remember the classification, but Amy will know it. You want to yell it out for me, Amy?
Jennifer Goodman,
Thank you.
Assistant Director. Those are senior office assistants.
Okay, we're moving on to our next item for public comment. Persons wishing to address the Civil Service Commission are asked to limit their total presentation to a maximum of 5 minutes for each side of the issue, or to submit their comments limited to 250 words or less by emailing sjcscpubliccomments@sjgov.org. Ms. Strange, do we have any public comment tonight?
No public comment.
So moving on to our future meeting dates, our next Civil Service Commission meeting is set for April 13th, 2022 in the Administration Building located here at 44 San Joaquin Street, room 146. We will keep that at 5:30, and then starting at our May 11th date, we will meet at 5:30.
2:30.
2:30, my apologies. I don't know what time zone I'm in. Appeal hearings, there are none for the board to hear tonight, and we do not have anything scheduled for closed session. Chair, will you please adjourn the meeting?
Before, I just don't want to make it on the record that I will not be able to attend the June meeting, June 8th meeting.
Thank you.
Right, and I'm for July the same, so.
Okay.
Hopefully there'll be others by then. Okay, thank you. Having no other business, this meeting is adjourned at 6:10. Thank you.